And news just coming in. Times now has accessed the judgment copy as well. It has just come to us. We've accessed it in a matter of seconds, of course, after this big row over how the Law Minister got it. It's a 114-page judgment in this case where all 5 petitions were dismissed today. We've accessed the copy and the Supreme Court has allowed reporters, including those at Times Now, to get access to copy now. We'll get you the detailed copy in just a bit, as my colleagues, of course, will be joining me in just a bit here. It's a 114-page. The most of it, the operative part, we already know, of course, but it'll be, of course, very good to read the entire judgment. It's not a huge judgment. 114 pages can be read in a bit. As far as the controversy around how the Law Minister got it first, we still don't have a clear idea how before the petitioner got it, the Law Minister did it and quoted from it in his press conference. Now we also have that particular copy and we will of course go through it line by line in just a bit as my colleagues will be joining us. Our colleague Anisha has gotten access to it from the Supreme Court PR department. Judge Loya's case, of course, the petitions in that particular case were all dismissed, all 5 of them today, earlier in the day around 10:30 a.m. And the 3-judge bench of the Supreme Court had come down hard on all the petitioners here, calling the petitions frivolous and with a mind of trying to scandalize the judiciary. These are very scathing words coming in that judgment here. The judgment copy is with Times Now. We'll show it to you in just a matter of seconds here. As far as the politics over the Judge Loya case is concerned, it continues. Earlier in the day, it was, of course, felt that after the scathing copy... Anand Narasimhan, my colleague, joins us now. Anand has the judgment copy. Anand, over to you.
Well, we've accessed page. This is the entire judgment copy. Going into the most important and the operative parts, page number 27 is where the petitioners and the interventions and the submissions which have been mentioned, which says Mr. Dushyant Dave, learned senior counsel appearing on behalf of the Bombay Lawyers Association, has premised his submissions on the foundation that the cause which he represents raises serious questions of general importance to the independence of the judiciary and the protection of subordinate judiciary against threats and or attacks. Mr. Dave emphasized the role espoused by the petitioners by adverting to the decision of this court in the Delhi Judicial Services Association Tisazari Court, Delhi versus State of Gujarat, in which the court regarded an assault on a judicial officer as something which affected judicial authority as well as the administration of justice in the country, in the entire country. Let's just scroll down a little more if we can. As we are opening this entire attachment. Now, this is what the court is observing. This court has observed that in order to make sure that justice is not only done, but also is seen to be done, and considering the involvement of the state police authorities and particularly the high officials of the state of Gujarat, we are compelled even in this stage to direct the CBI authorities to investigate the matter. This is in the judgment of Ruhabuddin Sheikh versus the state of Gujarat. This is what the court had observed. So these are the parts which have been mentioned. I'm just scrolling down further in terms of the submissions that were made. These are all the submissions. We'll move to the conclusions further down here in the judgment as we move to the other pages. Page number 30, as we come across to page number 30. Based on the background, Mr. Dave has submitted that the respondents should be directed to file appropriate affidavits on oath having regard to the fact that jurisdiction under Article 32 is extraordinary in its nature and scope. Now, further down, Mr. Dave has submitted that the discrete inquiry and report prepared by Commissioner of State of Intelligence Department is an attempt to stall an independent investigation. It is, according to him, unusual for the state government to order a discrete inquiry on the basis of a report published in a news periodical. Highlighting the sequence of events, it is urged that on 23rd November 2017, the state government directed the commissioner to conduct a discrete verification, and on the same day, a letter was addressed to the Chief Justice of Bombay High Court seeking to record the say of 4 judicial officers who had accompanied Judge Loya to the hospital on 1st December 2014. The High Court of Bombay communicated the approval of the Chief Justice on the same day. So the judicial officers submitted their statements within a day. The report was submitted by the Commissioner on 28 November 2017 within 5 days. There is in his submission a sense of alacrity which is not ordinarily found among public functionaries. So Dushyant Dave is actually questioning how is it that the discrete inquiry happened with such alacrity and with such speed, and that the statements were recorded in record time is the question that is being asked. Now going across to paragraphs 27, 30 and 40 as we go into page number 48, page number 53, coming down to page number 53, as my team is helping me go through the conclusions and the submissions. Page number 53, paragraph number 27. let's just come down. Now, this is where it is. Section 174 CRPC. And this is the Code of Criminal Procedure. And they explain what it means, where the officer in charge of a police station or some other police officer specifically empowered by the state government in behalf receives information that a person has committed suicide or has been killed by another or by an animal or machinery. Now, further down, this is the procedure that is to be that's been outlined under this section under CRPC. Let's go down to as paragraph number after 27 into 30. Scroll down further, please. As we go down further here on this page, these are all under CRPC what needs to be done. Now, the scope of an inquiry under section 174 of the CRPC has been considered in several decisions of this court, and they're saying under what sections as it is being invoked. Further down, as far as in terms of the principle was reiterated in Amar Singh versus Balwinder Singh, so the court has observed. So these are the observations. As we go down further, from page number 53 to page number 76. Page number 7. Now, this is paragraph 48. Learned counsel appearing on behalf of the petitioners as well as the interveners have sought to question the course of action which was followed by the judicial officers after Judge Loya complained of chest pain in the early hours of 1st December 2014. Why they have queried, was he taken to Dande Hospital initially and not to a specialized cardiac care facility when it was available within a radius of 5 kilometers of Ravi Bhavan? This line of argument is without merit. Judge Loya, as the statements of Judge Kulkarni and Judge S.M. Modak indicate, complained of chest pain at about 4 a.m. on 1st December 2014. His colleagues who were with him took a decision in good faith to take him to Dande Hospital, which is in close proximity to Ravi Bhavan. The issue in the present case is whether Judge Loya died a natural or unnatural death. To attribute motives to his colleagues who were with him and took immediate steps to shift him to a hospital nearby is absurd, if not motivated. In hindsight, it is easy to criticize actions which are taken by human beings when faced with an emergency. It is easy for an observer sitting in an armchair at a distant point in time to assert that wisdom lay in an alternate course of action. That can never be the test for judging human behavior. Very, very severe indictment. Let's stay on this a bit. The conduct of the colleagues of Judge Loya in attending to him is not in question. They did their best under the circumstances, acting entirely in good faith. At Dande Hospital, the medical advice was that the condition of Judge Loya required him to be shifted to a specialized cardiac hospital. Judge Rathi, who was attached to the Nagpur bench of the High Court at the material time, was with Judge Kulkarni and Judge Modak when he was shifted to the hospital, as was Judge Vaikar. Dr. Pankaj Harkut was a relative of Judge Rathi, was a cardiac consultant attached to the Mediterranean Hospital. Judge Rathi contacted him on phone, and it was at his suggestion that the judges took a decision to shift Judge Loya to Mediterranean. To find fault with the judges for this course of action is unacceptable. But there is another and more serious aspect of the line of submissions which has been urged. Though, as we have noted earlier,
right,
the proceedings
have to stop you there for a second. We have to take a very quick break. We'll return to the full court order copy there that Times Now has access before anyone else. Unfounded aspersions being cast on members of the judiciary is what the Supreme Court bench has taken exception